Um, Thank you. I'm speaking today from the country of the Bundjalung people. Before I get started, I want to tell you a short story about my interview with who I will call Sandra. About 2/3 of the way into our conversation, I circled back to the understanding of well-being that Sandra initially shared and what I thought I was hearing. But what I was actually hearing was the perspective I had retained from my earlier research participants. I said, and I quote, "Okay, so I'm hearing the perspective that physical and mental health might lead to or be part of a puzzle which enables a sense of happiness and balance, as in an understanding of well-being, but that maybe physical and mental health in terms of workplace physical and mental health is not the only thing that can create happiness and balance. Is that your perspective?" But Sandra's reply sent me plummeting past the point of no return in my research. She said, "I guess so, but it does weigh into your mental happiness. Like, isn't that the same thing?" And that's when I realized the logic that well-being is happiness, mental health is happiness, and that mental health is therefore well-being. To view mental health as well-being is what lawyers would call the smoking gun of my research. That smoking gun provides a significant connection between the definition of health in the law that I am researching and the concept of well-being. Ladies and gentlemen, this is important because I am asking whether the reach of that law currently extends to touch the well-being of its legal subjects or not. In the wake of the waves of COVID-19, individuals feel visceral impacts of law in their daily lives. To Miranda, who was my first interviewee, well-being is an inner knowing, guided by a gut feeling. Whether law can reach to touch the guts or well-being of societies is a question that is rising to the surface of the world in the post-COVID debate. That question is particularly acute in the context of the world of work, and it is arguably those who work for themselves in small business who are feeling the force of those restrictions most acutely. In Australia, model work health and safety law has been enacted in 7 of our 9 jurisdictions, including New South Wales. Yet the word well-being itself is not included in the statute law. However, there are some cases in the last decade which apply provisions of that law and use expressions which are quite curious. Those expressions include health and well-being, or health, safety and well-being. Yet the expression which is included in the duties prescribed in the statute law is health and safety, with no mention of well-being. The question of whether that statutory expression health and safety indeed means or includes well-being in the contemporary context of 2020 and beyond has not been asked nor answered in the courts of law or settled in the legal commentary to date. With rates of entrepreneurship higher than the national average, the Northern Rivers region of far northeast New South Wales provides the locale of my study. The aim is to explore whether the reach of the self-duties that self-employed persons owe to themselves in this region extends to touch their well-being. Why or why not, and if so, how? Those self-duties are located in 2 sections of what is called the Work Health and Safety Act, which I will refer to simply as the Act. Both duties are defined as health and safety duties, and common to them both is the expression health and safety. And as alluded to earlier, the well-being question which I am casting in this research is whether health and safety means or includes well-being. The purpose of this presentation is to demonstrate 3 ways of exploring the well-being question through juxtaposing significant themes of Sandra's story as crafted from her interview transcript with legal methods of reading the Act. Legal methods are called statutory interpretation rules, and they require an examination of the text in the Act itself, its context in the Act, and as well as that, the purpose or object underlying the Act, and the statutory interpreter is permitted to consult materials beyond the Act itself to give effect to Parliament's purpose. They also include the contemporary meaning of words. So let's start back at the beginning. This is what Sandra initially told me. Well-being is being happy, comes from your inner mind health as well as your physical health, a sense of happiness and content and balance. I do things that make me happy. I don't consciously go, I'm going to go and do this for my well-being. I like spending time with my family and my husband, reading a book, and I enjoy working as well. Like that rolls into my ball of happiness, I guess. And I love my circus stuff. I do aerial skills a few times a week. I feel responsible for my own well-being. The beginning of Sandra's story implores the perspective that well-being is a decidedly non-legal issue. Both self-duties delineate that what the self-employed person owes is a duty for her own health and safety at work. Working is of course rolled into Sandra's ball of happiness, but it is mostly her non-work activities that make her happy. The setting of the Act is clearly intended to be at work. The main object is to achieve a nationally consistent framework to secure the health and safety of none other than workers and workplaces. And that object is principally achieved by protecting workers and other persons, including self-employed persons, against harm to their health, safety and welfare through the elimination or minimisation of risks arising from work. The subject matter of the Act is demarcated to be the management of risks arising from work. So well-being is initially cast down as a non-work and accordingly non-legal issue. This perspective is supported by Safe Work Australia. Published in January 2019, the National Guidance Material to the Model Law states that a best practice approach to developing and sustaining a psychologically healthy and safe workforce should focus on mental illness prevention and mental health promotion, but that work health and safety laws themselves do not require any duty holders to provide health promotion initiatives. Well-being therefore lies in law's lack, beyond law in a personal responsibility and perhaps an organisational responsibility resting on best practice. But here's the messy middle. This is what Sandra went on to tell me. As a company, we're mortgage brokers. We do yoga Monday mornings. It's a team yoga. Starting the week nicely, just stretching our backs out from sitting in the chair all day. And meditation at the end. It's obviously very healthy for you as well. Law's there to protect us, keep us safe. Sandra's story is now entering legal territory. It is important to establish the context of the expression health and safety in the Act. Although the expression itself is not defined, health is defined in the definition section of the Act as follows. Health means psychological and physical health. In charting the usual course of consulting the Macquarie Dictionary for ordinary meanings of undefined terms, it is plain that the words psychological and mental are synonyms in respect to the meaning of or relating to the mind. However, what psychological or mental health means or includes is unclear. Internationally renowned health and safety expert Tuma cites the World Health Organization's definition of mental health as more than the mere lack of mental disorders. This rests on a positive dimension of well-being as stressed in the World Health Organization definition of health itself. That states, health is a state of complete physical, mental and social well-being and not merely the absence of disease or infirmity. Turmer's commentary was curiously and perhaps ominously published in March 2020, and it implores the legal responsibility, I repeat, legal responsibility, to proactively promote positive mental health. Although this commentary is in sharp contrast to the national guidance material published almost 1 year earlier, Turmer's premise is based on a connection between promoting positive mental health and risk management. That is, in order to eliminate or minimise risks to work health and safety, duty holders can promote positive mental health, particularly through creating workplace conditions which are conducive to optimism and resilience. Turmer goes further and advises how line managers can promote well-being, which includes none other than promoting non-work activities such as exercise, sleep, nutrition, and mindfulness. Sandra's Monday Team Yoga may be read as such a risk management strategy, and accordingly forming a nexus or connection between well-being and the legal duties she owes not only to her employees, but importantly to herself. Although my research is limited to exploring the scope of the self duties, it does pose practical implications for reading well-being into the nexus of both uni and bilateral work health and safety duties under the Act. Furthermore, Sandra insists that the law is there to protect us, to keep us safe. The main object of the Act is principally achieved by protecting workers and other persons against harm to their health, safety, and welfare. Sandra's view of protection aligns with the stated object of the Act. In imputing the definition of the health with the expression health and safety, one can read psychological and physical health and safety. However, whether the scope of the Act extends to both psychological health and psychological safety requires recourse back to its object. That object is to secure the health, safety, and welfare of workers and workplaces. As welfare is undefined, we go back to the Macquarie Dictionary to find the ordinary meaning, which is curiously the state of faring well, well-being. The definition of welfare therefore imbues the metaphor of well-being, and the meaning of well-being is indeed defined in the Macquarie Dictionary as good or satisfactory condition of existence, welfare. Therefore, a reading of promoting well-being as a risk management strategy is principally supported by the main object of the Act, which is to secure the health, safety, and welfare, read as health, safety, and well-being of workers and workplaces. So here's the ending of Sandra's story, with the smoking gun explained. Well-being is health, and it is being mentally healthy, physically healthy. So to me, that is well-being. So I don't see why it's not included in health and safety. Well, because if you're mentally happy, then you're happy, right? And if you're mentally unhappy, then you're not happy. And like if you're just putting wellness onto happiness. And if you're physically unwell, then your wellness isn't there either. I guess I mean like mentally healthy people are happy people. To me, being mentally healthy is setting goals and wanting to achieve things. Being happy, and maybe your happiness doesn't mean you have to set goals and you're just happy being happy. Or maybe you're a person that wants to achieve and has all these desires. You know what I mean? The ending of Sandra's story creates a cyclical structure with its beginning. That is, well-being is health. In imbuing this metaphor, the expression health and safety simply becomes well-being and safety. Yet the rhetorical question which Sandra ends with begs the understanding implored by Schulte and others and in 2012, that true well-being requires autonomy. Sandra's mental happiness is derived from setting and achieving goals. And that is indeed consistent with eudaimonic well-being, which dates back to Aristotle and earlier ideas of flourishing, which Richard mentioned. However, nowhere in the Act, its regulations or codes of practice lies the requirement for duty holders to set and achieve goals. Rather, the content is predicated on ensuring and taking reasonable care for health and safety. The very design of the work health and safety duties is sufficiently flexible to accommodate each duty holder's own decisions about how to fill the content of discharging her own duties. And it is precisely the self-employed person herself who controls her own work environment and embodies her own physical and mental health. Ladies and gentlemen, from Sandra's interview onwards, I could not unsee the perspective that mental health and well-being are the same thing, and therefore that the reach of the current law does indeed mean or include well-being. This perspective poses practical implications for the extent to which duty holders may be found liable under the Act, as well as the well-being of self-employed persons, organisations and societies in a post-COVID world. Thank you.
Thank you so much, Emma. That was excellent. Very, very good.
Well timed. You were before your time by 30 seconds.
Oh, yay! Thank you.
Does anyone have any questions for Emma?
Not so much a question, but I think everybody at this stage is starting to understand that mental health is not just, like well-being isn't just mental health. And isn't it funny though, that there is such an enormous amount of pressure on self-employed people to fill those gaps themselves?
Absolutely. So that's such an interesting perspective, Leslie, because there's a really big sense of well-being as being more than health, more than mental health, more than wellness. And nobody can really put their finger on what that more is in the literature, which is really interesting. And I interviewed 30 people who work for themselves, and a lot of them kind of got stuck on relating their understanding of well-being to the law. Like they all were able to talk for quite a long time about what well-being is or what it means to them. Even if they had trouble defining it, they could still talk based on their, I suppose, common sense and human understandings. But then when it came time to think about its place in the law, some people rejected that outright, even if their earlier understanding of well-being sort of matched what the law might be saying. And then other people saw no reason why it shouldn't be included, because they would really welcome that, because exactly what you said, Leslie, they don't want to be on their own figuring it out. They want somebody to tell them what to do, how to ensure their business succeeds, and how to ensure they don't burn out in the process. So there's this real duality between the one camp of participants who see law as something that is there to protect us and keep us safe, like Sandra thinks. And then there's a smaller camp which says, well, hey, I don't want Big Brother. Law doesn't belong in my well-being. There is absolutely no way I would listen to what the law says if it relates to me in terms of how well I am. It's none of the law's business. I wouldn't follow it anyway. So yeah, exactly what you're saying there, Leslie. And this is an area of law which has massive conflicting policies and purposes. So we also need to think about not only the potential benefits of having law to regulate and perhaps help or be in the toolkit of a small business owner, but the danger of that. And we're seeing that quite acutely with COVID and the extent to which restrictions do impact not only our physical lives, but also our mental headspaces. So I think it's a really great time to see not only law's positive effects, but also the danger and the slippery slope that it can go down if we let it.
I think it would be interesting to, if we get to the point of how the law defines well-being, because as you said before, it's so challenging to get like a very succinct answer to that. You know?
Exactly. And at the moment, this law that I'm looking at refuses to engage with that directly, but it does it quite indirectly through health. But if we look at other laws, so beyond this act, we can look at cases and quite old cases. And it's really interesting because they say well-being is welfare. And then that goes back to the purpose of the act. So I think one other potential reading, which is sort of the middle ground, is that Wellbeing's not part of what you can be liable for under the Act, but it's a byproduct or an intention of the Act, but they can't prosecute you if you don't look after your wellbeing because they can't see whether you're doing that or not. Yeah.
Very interesting.
Yeah, very good. Is there any other questions? Richard?
Hi, Emma. That was a great talk. Thank you. It was a wonderful exercise in statutory interpretation. Conceptually, I have no difficulties understanding that mental health is probably a concept that includes well-being. And yet I found myself somewhat surprised when you sort of got to the point, as I understand it, where you said you could find an interpretation of the Act in terms of its objectives of saying that the Act really does encompass well-being as this sort of broader concept. I guess my question for you, and this is perhaps just a clarification, is the regime about creating an obligation to really prevent risk to mental health and well-being, or does it go a bit further and say you actually have an obligation to promote good mental health and well-being?
Great question. So that kind of goes to that smoking gun question. That's a really good pickup. So the intention is to prevent, but the subtext is to promote. And so a way to prevent is to promote.
Although I conceive them as being different, like different.
Yeah. There's not a positive, it's not a positive obligation, such as if we can think of maybe affirmative action programs and equal opportunity, that sort of thing. It's not like that. It's very much prevention, but through that, the one way in which to prevent a risk to workplace health and safety is to promote well-being. So that's where that reading can come into it. And so we can see risk management strategies as rapidly evolving. So, and another example would be wearing PPE in COVID times. So how that, the content of that can rapidly change, but the scope of the duty itself, there's a couple of ways to look at that, whether it's a risk management strategy or whether it's written into the duty. So thank you for your question.
And one thing I think that follows from that is I think you can start to see at that point the bleeding between the professional and the personal. I think that is that sort of, well, what is the interaction between those two spheres?
Yeah, excellent. And that's why I'm studying self-employed persons, because they embody those two things. Yeah, well done. Kate has something to say.
The question from Kay is, in the context of affording employees procedural fairness, which would tie into that sense of well-being in the workplace?
Yeah, because there's a sense of, there's something called occupational justice, and that links to fairness, and some definitions of well-being definitely go to fairness. So thank you, Kay. It's a great question, great comment.
Thank you so much, Emma. That was an excellent presentation and very, very good responses to the questions.